We are ready to go? Sorry. That was a little bit intense. We are now up to a very, like just all the others, but let me say that last year at the end of Global Procurement 1, we said that we really wanted to debate the possible interaction of public procurement and human rights. And let me say how delighted we are that we have such two distinguished speakers for a topic that may be extremely critical for the well-being of societies, because most of the time human rights respect maybe affect a minority of society, but the lack of respect towards that minority defines a society. So we really want to see if in public procurement there is a tool to make sure that a country can call itself among the countries that respect the nature of man. So these two fantastic speakers that we have managed to, whose presence we have managed to obtain at Global Procurement Conference number 2 are Professor Christopher McCrudden and Professor Tunde Tatrai. Christopher McCrudden is Professor of Law at the University of Michigan, Professor indeed of Human Rights and Equality Law at Queen's University Belfast, practicing barrister at law with Blackstone Chambers, and to most of you very well known for his fabulous book, Buying Social Justice, Equality, Government Procurement and Legal Change by Oxford University Press. I must tell you that if you're in the procurement profession and you have not read that book, well, there is really something missing in your professional and human life. So I really recommend it. I told him, and I say it in front of everybody, that probably it is, in my opinion, it is the most important book that has been written about our profession. So I recommend it strongly. And then Tunde Tatrai, a dear friend and a great economist and lawyer. It is wonderful that we finally have interdisciplinarity is becoming so obvious that now we have a person that defines explicitly and formally herself economist and lawyer. This is a big success. I don't know if it's because of what we did, but certainly it's a fantastic thing that things are changing in the right direction. She's associate professor at Corvinus University of Budapest at the Institute of Business Economics. She teaches EPROC, Sustainable Public Procurement, Ethical Procurement, Public Procurement Law. She's member of the Public Procurement Stakeholder Working Group, European Commission, and I might add, she is the companion, my companion for several journeys across this wonderful exercise that we do every year and a half called the Public Procurement Interdisciplinary Symposium. And by the way, I should say to everybody that maybe I've said it already, that two things. In July or maybe in early September, Routledge will publish the papers and the debates in Belgrade that underwent under the third interdisciplinary symposium. We will make sure that everybody comes to know about that thing. And that the fourth interdisciplinary symposium is going to be held in Paris under the supervision of Tunde, Professor Stéphane Saussier at the Paris School of Economics, and myself. And we look forward to several very interesting discussions, as I always say, in a very boring and dull city like Paris. So, having said all this, and reminding you one last thing, that there is no coffee break. So if you want to get a coffee, coffee is there, but just get up very silently and leave the room. We will go forward, and I think that Christopher will be the first. Thank you for being with us. We're very honored to have you here.
Thank you. It's a pleasure to be here. And Gustavo, thank you for your very kind remarks at the beginning. I, of course, agree with everything that you say. So we're talking about human rights and public procurement. And I should start by saying that I can't work this.
Does it work?
It's going to work. Okay. Thank you. Thank you very much. Thanks. So what I was going to say was that, thank you very much, was that I've adapted somewhat the slides that I was going to use in light of the discussion over the last couple of days in order to make it more focused on several of the themes that have emerged in the previous sessions. The more extensive slides are available to you, but I'm going to focus on really just a few key points. And what I want to do is essentially to draw out my argument and to try to sustain that argument. And the argument essentially is quite simple. The argument is that human rights, and I'm putting quotations around human rights, is a problem for public procurement, and public procurement is a problem for human rights. So this does not start from a very happy position. And the question is what to do about that, what to do about procurement being a problem for human rights and vice versa. And the solution is very far from clear. So what I want to do today is essentially to problematize that relationship rather than advocate for it. The assumption always is that if you're a professor of human rights, you're in some way acting like an NGO advocating for a particular solution. And in this case, I'm not. In this case, I want to share the problem and see whether together we might be able to make some progress on it. So there's a lot of recent studies and networks that have been set up. And here's just a few of quite recent analyses of human rights and procurement. So quite an extensive survey was done of 20 jurisdictions a couple of years ago. Stumberg and his authors have produced an extensive survey of the relationship between human rights and procurement in the US. There's now a learning lab on procurement and human rights set up by Danish human rights bodies. So there's a lot of it going on in terms of this relationship. And indeed, there's several recent examples of what I'll call linkage, that is the relationship between procurement and attempts to deal with human rights. Just to take two random examples, the Modern Slavery Act in the UK and the US executive order on strengthening protections against trafficking linked to procurement. So, in other words, we're in a study in an area where there's quite a lot of attention being given now specifically to that relationship between human rights and procurement. And the question really is why we want to use the terminology of human rights at all. So one of the problems, I think, that we need to begin to grapple with is that many of the issues that we've discussed already over the last 2 days, gender equality, world development indicators, sustainable development goals, they're all involving human rights. So why would we want to introduce specifically human rights language into the discussion? Because human rights fits under the much more familiar social issues discussion that's been going on in procurement for the last 20 years at least. So what does the shift in language between social issues and human rights, what does it bring into the discussion? So Farid Yakar's presentation this morning, very interestingly, has, under the social issues, has a whole list of gender equality and so on, and human rights. So what exactly is going on here in terms of the relationship between these different concepts? So what difference does it make if we use the language of human rights? And the reason is going to be relatively simple, but let me just explain what we mean by human rights, because there's a lot of sometimes unclarity, and I speak now as a lawyer. So for me, human rights are essentially those rights that are guaranteed under a set of treaties and conventions at the international level. And here they are. So, when we ask what are human rights, usually quite skeptically, that's what I mean by human rights. So what is the point then that emerges out of the human rights conventions that I've just mentioned? And what we'll see is that each of the major human rights conventions has something like the following structure. So one of the articles essentially says these are legal and states have to obey them. But usually, and as we'll see in a minute, these conventions also have a provision like the one that is in red. So each state party, that means essentially each country, shall prohibit and bring to an end by all appropriate means, including legislation as required by circumstances, racial discrimination by any persons, group, or organization. And the question, of course, is what is by all appropriate means? And this isn't a recommendation, this is a legal obligation by states that they use all appropriate means. And you get exactly the same issue in the International Covenant on Civil and Political Right. Again, existing legislative or other measures. You get it in the Economic, Social and Cultural Rights Convention. You have to enforce it by all appropriate means. You get it in the Elimination of All Forms of Discrimination Against Women, to take all appropriate measures to eliminate discrimination. And each of the other major conventions has exactly the same language. And the question, therefore, is, well, what's the relationship between that set of provisions and procurement? Well, so what exactly is emerging then from the international human rights debate? And essentially, the limitation in international human rights is that it generally applies to states. States are obliged not to discriminate. States are obliged not to deprive someone of health care, etc. So human rights generally don't create direct legal obligations for businesses under international law. Generally, that's not the case. So we then get to a very important distinction. And if you get this distinction, you will understand what I'm about to say for the rest of the conversation. Yeah? So there is a distinction in law between what are called negative obligations and positive obligations. So a negative obligation is the state shall not torture. A positive obligation essentially is the state shall prevent other people from torturing as well. Yeah. So the penny, I think, is beginning to drop, as we say in English, which is, therefore, if you combine this notion of positive obligations arising under these conventions with the requirement to use all appropriate means to deliver on these promises, then we get really quite a heavy legal obligation on states to essentially prevent third parties, including businesses, from breaching human rights. Not that the businesses have the duty. The businesses are the subject of a duty on the state to restrict them from abridging human rights. And here's the key point. The key point is these obligations that apply to states are legally binding. They're not advisory. They're not discretionary. They're legally required. Okay. So what kind of human rights then are we talking about that apply to companies? And let's just take some examples. So let's take an example of a food processing company. And it contracts with a recruitment agency that uses trafficked workers and refuses to give over the passports until they've worked off their debt to the agency. No? Or let's take the example of a mining company that pressures the government to initiate criminal proceedings against peaceful protesters. Or let's take a manufacturing company that discriminates against unionized employees in hiring decisions. Let's take an example of a chemical company that dumps toxic waste without precautions so that the toxins get into the water supply and cause diseases in the community. Let's take the example of an agricultural business that engages in forced evictions, resulting in displacement and loss of housing. Now, each of those, of course, raises central human rights requirements, and in each of them, I've specified the specific article in the international covenants that's applied. So, another example, just and favourable conditions of work. Clothing retailer contracts with a supplier that pays workers less than the minimum wage. So what's all this got to do with public procurement, right? So businesses shouldn't do those kinds of things. The state should try and prevent them. So why procurement? And the question, of course, then is, well, procurement measures are part of the potential measures that can be operationalized by the state. And if they're available to be operationalized against these measures, then the state, under these various provisions, has an obligation to do so. So we get into this rather interesting question, not of whether public procurement should be used, but rather responding to the legal requirement that public procurement be used as one of the measures that's available to the state. So the problem that arises in each of the examples that I gave to you essentially is, well, what happens if the company, the business in each of those examples is fulfilling a government contract at the time of the action that we object to? Then we have a problem. We have a problem because the government seems to be not just failing to act to prevent the company from abridging these human rights, but that it is in some ways complicit with the company in doing so. So, essentially, we've seen, as was pointed out earlier on, a dramatic development of green procurement policies. And now we've got a lot more interest in the, I'm going to suggest, rather different area of social procurement, including now human rights. And there are essentially three major obligations that states take on when they sign up to human rights requirements. The duty themselves to respect human rights, so the state can't torture people. The duty to protect human rights, meaning that the state shouldn't allow businesses to torture people. And it's essentially those two that link directly to the procurement measures. So, just to emphasize again, we're talking about the positive obligations on government. So there are three ways, essentially, of viewing the relationship between this kind of law and public procurement and human rights. And each of these is problematic. So, first of all, the question arises, well, to what extent do human rights instruments prohibit or limit the state from engaging in public procurement in the first place? Right, so we've assumed in most of the discussions that, of course, you're going to use public procurement, but that's a choice. It's a choice in many instances whether to use public procurement. Right? So, for example, it used to be the case that instead of the state contracting with a private body to build a building, the state had a direct labour force that built the building itself that was employed by the local authority. So the question of whether to use public procurement is itself a choice. And one question that arises is, well, does human rights prohibit or limit the ability to engage in public procurement in the first place? Second kind of question is, to what extent is there an obligation to use public procurement as a tool to deliver human rights? And the third question is, to what extent do international and regional economic law, like the European Union or the WTO, permit the use of public procurement to deliver human rights? So there's a potential, obviously, tension between the second and the third. And the reason why there's a tension is that international human rights seems to be pushing government to use public procurement to tackle human rights violations. And, at least on one interpretation, international and regional economic law seems to be pushing against the use of procurement. So there seems to be, therefore, a conflict at the international level, at the regional level indeed as well, that essentially procurers and governments and businesses are being told to face in opposite directions. Yes, you must do it. Well, no, you mustn't. So there's a problem. So let's start with the first one. To what extent do human rights instruments prohibit or limit the state from engaging in public procurement? Well, here we get to the major question about in what circumstances, if at all, is privatization a breach of human rights obligations? And that's been talked about in the literature quite a lot. Right? So to what extent, for example, when you privatize water and you suddenly make water chargeable in a context where people cannot afford to access the water that is now privatized, to what extent is that a breach of the right to water? So in other words, what I'm suggesting is that there are potential limits to the use of procurement as a device in the first place. That isn't often discussed in procurement conferences, if I may suggest. So I'll come back to the point about commodification in a minute. But let's move on to the second issue, which is to what extent do human rights require procurement to incorporate human rights standards? And the answer is yes, to a degree. So here's the UN Guiding Principles on Business and Human Rights. So the UN Guiding Principles state quite explicitly, states should exercise adequate oversight in order to meet their international human rights obligations when they contract with or legislate for business enterprises to provide services that may impact on the enjoyment of human rights. Guiding Principle 6, states should promote respect for human rights by business enterprises with which they conduct commercial transactions. Seems relatively clear to me. So the commentary on Principle 6, even if the principle itself wasn't clear, the commentary is quite clear that commentary talks about unique opportunities to promote awareness of and respect for human rights by enterprises, including through the terms of contracts. With due regard to states' relevant obligations under international and national law. Well, then that gets us to the third problem of to what extent does international and national law permit these obligations to be put through public procurement. So in terms of the UN Guiding Principles, you'll see that there are several national action plans on business and human rights. And so far as I'm aware, all of the ones that have recently been published, all of the national action plans, Denmark, Italy, Netherlands, and the UK, all address public procurement as part of their obligations. So then we turn to this interesting question. Well, there seems to be a push by international human rights to incorporate human rights into procurement. But on the other hand, we've seen this morning, for example, in terms of green procurement or social procurement, that there may be limits in terms of the ability to actually do it legally under international and regional and economic law, under procurement law. So what's the problem? Well, the problem essentially then is the legal one, but the one I actually want to focus on is not the legal one, it's more the question of workability in this kind of context. So are we able actually to work with the idea of human rights in the procurement context? And again, I'm going to suggest that that's not by any means an easy question to answer. So I'm going to suggest that there's essentially a gap. Those of you who are familiar with the London Tube will know the famous line, "Mind the gap." Yeah. So this is meant to prevent you falling down between the platform and the train. I've always wondered why you don't just build a better platform, but leave that aside. Mind the gap is the phrase. So I'm going to suggest that you need to mind the gap here between human rights understandings of human rights and public procurement understandings of human rights. And essentially, there are two contrasting views. These are almost parodies. Yeah? I'm not sure anybody actually believes fully in either of these, but they're meant to be models to contrast and to provoke discussion. I think not just to provoke discussion, but to provoke you, to be honest. So what are the different and contrasting views of human rights? Well, let's think about a procurement practitioner's view of human rights. So it's all contextual. Right? So essentially, human rights are to be seen as embedded in a particular local context. They're a problem to be dealt with, but they're a problem to be dealt with because the local context makes it a problem. They're discretionary. So the way in which human rights is usually talked of in the public procurement context is it's sort of like corporate social responsibility. They're good things to do, and in particular, if you can argue that they're good for the business and there's an economic case for them, then all to the good. So practitioners prefer clear rules of the game, right? Rather than having to exercise judgment. In my experience, most public procurement practitioners hate having to exercise judgment over issues that they're not familiar with. They like clear rules, yeah? That's why an awful lot in the past used to like, in particular, awarding contracts on the basis of cost only, right? So that was simple rule. All of this new stuff is really complicating. And if you add human rights on top of it, then it really gets terribly complicated indeed. So from that point of view then, just continuing on, public procurement is a specialized operation from the point of view of procurement experts. to be run separate from interference with public and political actors. So you want to immunize public procurement from politics. Well, human rights isn't immunized from politics. You want the criteria for awarding contracts, and this came up in the discussion this morning. In fact, both of you referred to the idea that you want to essentially be able to monetize the values in the relationship. Well, can you monetize human rights? So, how much are you prepared to give in order not to be tortured? Well, what's the cost or the value of human dignity? To what extent is it, would you pay as a public authority to be able not to discriminate on the basis of race? These are sort of problematic. So the whole commodification of human rights in the public procurement context is a problem. It's also the selectivity in the context of a practitioner's view of human rights. So you focus on some things at a time, right? You focus on child labor, or you focus on trafficking. In fact, you generally focus on whatever's sexy at the time. Yeah? Whatever NGOs are pushing are those things that are then addressed. No comprehensive view. So human rights then, finally, are in most procurement contexts, if they're addressed at all, they're addressed at only one stage of the procurement process. Yeah? And then you address them at one stage and you pat yourself on the back and you say, there, we've dealt with human rights. So, as I say, a parody of a practitioner's view of human rights. They're basically an irritant, to be honest. What do human rights experts, practitioners, lawyers think of human rights? Well, in all of these, it's exactly the opposite. Right? Human rights are universal. They're not contextual. They're legal requirements. They're not simply advisory. They are requiring interpretation and judgment. Right? So when we say this is a violation of human rights, this requires a judgment. It isn't a rule. It's an application of a principle to a particular situation. So what constitutes torture? Is this person discriminated against on the basis of race? Have they been deprived of the right to water? And so on. And each of those judgments, in many cases, requires essentially an idea of proportionality. You've got to make a judgment. And you have to have an understanding of the limits on the rights as well as the scope of the rights. They need to be mainstreamed across all functions of government. No function of government is immune from these principles. Most importantly, perhaps, you can't monetize the human rights values. So as I said, what's the economic value of human dignity? So there's a generally different worldview, and if I can put it sort of pretentiously, human rights thinks of itself as dealing with values from a deontological point of view. They are valuable in themselves. They're valuable in themselves. They're not instrumentalized. They're not valuable because they contribute to the business. They're not valuable because in addressing them, you avoid political problems. They're valuable in themselves. This fits very uneasily with essentially a utilitarian view of public procurement. And you have to deal with all human rights, not just a selection of them, not just child labor, not just the ones that have a particular pressure point from the NGOs, but all of them. So, finally, human rights need to be considered throughout the procurement process, in terms of the definition of the contract, in terms of whether you have procurement at all, in terms of the selection, etc., etc., etc. Not just one stage. So, what do we do about this then? Well, question I want to leave you with is, can practitioners, procurement practitioners, you, cope with human rights? Human rights from a human rights point of view, not human rights from a practitioner's point of view. So it's clearly a challenge and it's an opportunity. The question is whether it's a necessity. And here's the problem, I think. And here I'm actually rather more sympathetic than I first might appear. I think it's actually unfair to practitioners in many cases because it requires, without guidance, without further guidance, it requires practitioners essentially to bear the risk of making these kinds of judgments, of debarring someone, of not awarding the contract in the first case. And these are both political, legal, and economic risks. And putting, your ordinary practitioner in that kind of situation, I think is really, really problematic. So the question then is public procurement too important to be left to procurement practitioners? Sort of echoing essentially the first talk at the very beginning of our process yesterday. So do we essentially transfer some public procurement functions like these out of procurement expertise and put it into the policy departments? That means procurement practitioners giving up some of the territory. I suspect that's not very popular. Or do we simply outsource the human rights issue to somebody else? Do we outsource it to NGOs? That's essentially what labeling is about. Right? That's essentially procurement practitioners leaving it to somebody else to make the hard decision and then relying on that. We can dress it up, but that's essentially what it's about. Or do we need a different type of procurement practitioner? And of course, that's the question about education. And of course, that brings us back to Gustavo, who is, of course, training all of you to be different types of procurement practitioners. Thank you.
Just the mere fact that you said it makes me feel responsible. So
Exactly.
I know. So you put us all on the spot. Tunde, your turn.
Thank you very much. So first of all, I'd like to make it clear that I'm a fully supporter of dealing with human rights via public procurement, although I will talk about the discrepancies relating to this topic. We realized, and I like very much your question about the obligation of the European Union regarding the supporting social considerations via public procurement. So we realized that a lot of, or most of the contracting authorities try to deal with it. Coming from the environmental side or from the social side, they try to be somehow sustainable. But most of them try to tick boxes, try to make it clear, especially based on the notices of the procedures, that even the awarding criteria or the minimum requirements or something in a contract as a disclaimer relates to the sustainable story, and then they will create statistics and show an evidence to the Commission, to the authorities and everybody that yes, we try to do our best and try to be as sustainable as we can. Could you please start my presentation? Thank you very much. So most of the market players try to do their best to tick those boxes, but when we look at the examples, we have to say that in a lot of cases, these solutions are not efficient enough, especially from the human rights point of view. For example, if they buy fair trade goods, they don't know if it is fair trade or not. Sometimes they simply try to deal with fair trade because it seems or it looks as trendy, and it's good to talk about using fair trade goods and services. Or employing unemployment people. It is very trendy in the Central Eastern European countries. Although we know that the service providers or the bidders employ the unemployment people for several weeks, and then afterwards they try to get rid of them because they have no clue about the services or goods they have to provide. So I do have to say that using contract disclaimers, we have more or less the same experience. So that's why I think this is time a little bit talk about the discrepancies relating using human rights in public procurement. I will deal with some of the exclusion rounds, so try to talk about examples coming from the European regulation, then a little bit talking about the modern slavery, the subcontractor's role, and some interesting typical solutions coming from the Central Eastern European side of the European Union. So, if you look at the exclusion ground of the European directives, you can see that we have an exclusion ground relating to child labor or other forms of trafficking in human beings. And of course, this is an exclusion if the bidder as a legal person is affected in this kind of things. But if you look at the end of the new regulation, you can read that the obligation to exclude the economic operators shall also apply where the person convicted by final judgment is member of the administrative management or supervisory board of that economic operator, which means that in public procurement procedures, we have to deal with the leaders of the company, the managers of the company. If we have to deal with them, then it's not enough to ask a self-declaration from all the managers of the economic operators, but somehow we have to give opportunity for contracting authorities to check criminal records. There are two ways of getting relevant information about these persons. The first is that we provide access to personal data for the contracting authorities. But in our countries, for example in Hungary, if I give direct access for a contracting authority officer to personal data, they will check immediately all their neighbors and of course try to get as many information as they can from the criminal record database. So this is another way of doing things. When I asked, last year I was the leader of the electronic power procurement regulatory subgroup of the Commission. And I asked all the member state experts if they trying or planning to open their criminal records. And except of one country, the answer was no, we are not planning. We do not want to open our records. And we do not want to develop a special public procurement criminal record database for contracting authorities. Well, then let's look at the other potential solution to oblige the persons concerned to give their consent to enable the contracting authority to have access to relevant information, which means that all the managers and affected person at the bidder at the other side have a feeling that if they say no, then the economic operator will not be able to apply for public procurement tenders anymore. So there is a pressure on them to say, yes, okay, I'd like to open my criminal record personally, which is against the data protection directive. So the data protection and the public procurement directive fight with each other, and we create this kind of regulations and exclusion grounds. We simply try to simplify the question because finally almost all the member states decided to accept self-declaration. And what does it mean? Self-declaration means that all the persons, all the managers say that yes, okay, I'm clean, 100% clean. And what is happening right now? Because of the over-administration of public procurement procedures, only one of the responsible managers says that all of us, all the other affected person at the bidder are okay and they are clean. And most of the contracting authorities have to accept this. So this is the way how we should not create new rules relating to human rights. And first we should deal with data protection issues and then creating new exclusion grounds. May I show you another exclusion ground? This is from Hungary. You know, we have serious migrant problems, not only in Europe. Just look at, I think yesterday read it, the Italian-Austrian border. The situation is very serious. If you come from Poland, Serbia, Hungary, Romania, Bulgaria, and let's continue, and Italy, it's really serious. But sometimes governments decide to fasten the procedure to get rid of migrants in countries. So they give them food, they give them opportunity to stay for a while, but finally they do not want to keep them in their countries. Some of the countries build walls. Hungary built wall, but did not follow the European Public Procurement Directive when they bought the wall. So, and some of the other countries try to solve the problem in a different way. The Hungarian government decided to create an exclusion ground. So, if as an economic operator, a potential bidder employs a migrant, somebody from the third country, unofficially, that bidder is going to be excluded from public procurement for 3 years, which is okay. We have to protect the human rights of migrants. But for those migrants who come to Hungary, their only chance to survive, to somehow to be employed unofficially for a couple of months, somehow to decide what to do, how to continue their way. And this exclusion ground, I think, is a good or a bad example for that. The Hungarian government decided not to let them to survive and immediately exclude those, because of the fine for public order offenses, we call it, because of the fine to get rid of, to exclude those bidders who do it. Of course, I know exactly this is against the human rights of migrants, but somehow we have to counterbalance the situation. This is the answer of a regulator. So I do not think that those answers, when we just regulate and create typical minimum requirements, avoiding criteria or this kind of exclusion ground, should be a good solution. Let's continue the story with another. With another example. A lot of very interesting articles were published about the modern slavery in public procurement. The whole story is about the subcontractor's role and the contracting authority's responsibility to get more information about subcontractors. In some of the member states, there is a maximum proportionality of the level of subcontractors. In some member states, contracting authorities try to make the direct payment of subcontractors obligatory, like in France. In France, it is more or less a working model. In Slovakia, it was working for 1.5 years, and then they changed the system. In Hungary, we tried it, but it failed. The contracting authorities had to over-administrate themselves, and it was too complicated for them for a lot of reasons. So we know exactly that there are some sectors like manufacturing, construction, agriculture, hospitality, when typically we have to face with short-term contracts or informal employment practices. But what should be the potential answer? Last year or 2 years ago, in the Interdisciplinary Public Procurement Symposium, Mr. Craven had a very good presentation about the UK answers for this challenge. One of the answers should be to control the supply chain and to shorten the supply chain. But let's think a little bit about the supply chain. Do we want less and less subcontractors in the shorter supply chain? Does it mean that we want a Foxconn, what Apple has? In the Foxconn, you remember the story, a lot of people suicided themselves because of the circumstances at the company. Apple would have an opportunity to control their supply chain. It was not so complicated, but it was so easy to outsource everything to one company. And that was the solution. So it does not really help us to protect human rights. Or let's think about the Rana Plaza case in Bangladesh. It's a terrible story. Some years ago, thousands and thousands of people died. And afterwards, after it was a producing company, when the media asked Boss and Zara and other very well-known companies if they were related, if that Rana Plaza company were related to their supply chain, they simply did not know the answer because they did not know their supply chain. Or look at the Kinder case when Ferrero, you know, the Ferrero company had a problematic situation because the media found families, it was this year at Easter, found families in Romania dealing with small plastic things to put it to a box, and then finally Ferrero created this chocolate egg. So at the beginning of the supply chain, there was typical child work, and Ferrero had no clue about the end of their supply chain. So it is not unrealistic to think that all the companies, all the producers have a clue about their whole supply chain. So to say in the regulation and make pressure on economic operators to shorten their supply chain is not realistic. If you wanna buy Toyota will not change the supply chain, even though Toyota knows the whole supply chain of the producing company. So I do think that theoretically it could be an important part of dealing with human rights to control what we can, but we have to know that we have a lot of limits regarding this serious work. And last but not least, some interesting examples when we try to do something in the name of human rights. A lot of very good researchers try to suggest things. For example, visiting supplier plants to ensure that they are not using switch-up labor, or asking suppliers to pay a living wage. Well, let's look at a European Court of Justice's decision, which belongs to this suggestion coming from Beamer Stephan and Helen Walker. The European Court of Justice decided in the Regio Post case, this is not CARE, excuse me, this is case, in the Regio Post case, that it is not against the European directive if, as a kind of minimum requirement or part of the contract, the contracting authority create an obligation for the potential bidders to give a kind of minimum wage, minimum salary for all the employees. At that time, when it was decided, there was no minimum wage, minimum salary at the postal sector in Germany. Then, a very interesting argument has started, if it is a good idea or not. This year, a new legislation took into effect not only in France, Germany and Italy, but in Austria as well, that all the logistic service providers have to give the local minimum wage when the driver goes through the country, through Austria, Germany, France, and Italy. And based on a brand new legislation, they have to offer hotel expenses too, which means that the regulators, in the name of the human rights of drivers, try to, well, counterbalance the situation and protect the logistics service providers in their countries. So in the name of human rights, they try to be as protectionist as they can. And I don't think this is a fair play. Let's continue the story with Let's continue the story with the very last example. This example is coming from Hungary. The government decided to increase the employment rate within prisons, because this is the prisoner's human right to be employed and to work in prisons. So the government created a governmental decree that all hospitals, universities, and other contracting authorities first have to ask prisons and the surrounding area if they are able to provide services and goods. And if they are able, they have to sign contracts with those prisons. Now, what is happening, and it is very interesting, we can see that in a surrounding area of hospitals, a lot of small and medium enterprises disappeared. So this solution destroyed the market generally. And I do think that they have an interesting consequence. It's very important to deal with human rights. And this is absolutely acceptable to help prisoners in prisons to do something, although those families whose businesses crashed are more or less unemployed, so we have to support them. So I don't think that from the other point of view it was a good solution. And of course behind the prisons there are a lot of private firms, so the whole story is not only of course about supporting social considerations via public procurement. But what we can see and we have to face with, that if we want to deal with a lot of objectives via public procurement, supporting social considerations, increasing employment rate, dealing with corruption, trying to be as efficient as we can in public procurement, supporting small and medium-sized enterprises, then we are lost finally. And some of the objectives are going to be controversial. So somehow, if human rights are important for us, then first we have to think about the potential consequences if we try to find a good solution. Yesterday, I heard a very interesting example about a disclaimer in a contract. Provided it respects the labor laws of the country where the bidder comes from. As a supporter of the disclaimers of the contracts, I do think that this is very important to talk a little bit more about the execution phase. But if we simplify it, and if we say that we do only have to respect only the laws of the country where the bidders come from, that we will not reach what we want to. I think one of the most important solution, and not a solution, but a kind of characteristic of this question is how to control the performance phase, how to control the execution phase if we really know that we want to support human rights via public procurement. Thank you very much.
Thank you, Tunde. Many issues on the table, including the one of the several dimensions of the goal function of a public procurer that makes it indeed complicated. Questions from the floor? Aris, I knew you were coming.
Thank you very much for your thank you very much for your very thought-provoking presentations that highlight the tensions that exist once we cross the Rubicon of accepting that, in fact, public procurement can and should be used to address some of what used to be secondary objectives I think in a completely wrong fashion, parallel or other objectives in the context of human rights. And your presentation, of course, also highlighted the fact that this tension is not only between the classical economic competition objectives of procurement versus human rights. We could have tension between human rights as well, when we use procurement as a vehicle to achieve some human rights objectives. Now, the question I would like to ask you is this. It seems to me that we reach a point if we agree that yes, this is a pathway that we could use to achieve human rights, to respect, fulfill, and implement human rights obligations that arise, and I'm thinking of the international covenants and obligations that states have undertaken. So once we agree on that, then the issue is how. It's the method. And it seems to me that, of course, one method is the labeling or the various standards or self-certification, that they are open to, of course, they have their flanks open to challenge how effective they are. And the other thing is how streamlined that process is. But I think one possible solution could be provided by new technologies here. And I would like to mention to you and all the panelists, the participants, I'm also involved in, apart from the learning lab that Professor McCrudden mentioned, in which I'm actively involved, and we had organized a workshop in Nottingham a few weeks ago where Dirk was participating from the EBRD. I'm also advisor of an NGO that focuses an anti-slavery NGO based in Geneva, the Slave-Free Trade, that's the name, where one of the, if you want, deliverables or methods is to use new technologies, GPS tracking, where one would be able to track an individual product to see if it is, in the context of anti-slavery legislation, it's a clean product. And something that perhaps could potentially go around and answer the specific question of how, because I think that's where we are missing, that's the missing link. We all agree that this should be done, and then we say, but how? New technologies, I think, could provide a possible solution and make things much more effective. Thank you.
So thank you very much, Aris. First of all, I'd like to remind you for a question which related to the gender procurement. I like very much when you differentiated the goods and services regarding the question. I think that's a very good point. So when we try to control the performance phase, and if you have a service provider, then it is easier to identify who are the real service providers, who are the real employees, and to find them, to check them, to control them, to get more information. And administratively, it is not extremely complicated. But if, regarding goods, you try to know who is the real producer, what is happening in China, or where is the materials come from, India or Ethiopia, and what is happening in reality, then we have to find that if we control and would like to control everything, first of all, it increases the price. Secondly, the bidders will hide their subcontractors. We can see that we have a new European single procurement document in the European Union. The direct aim of filling this document to decrease the level of administration. So all the capacity organizations, some of the subcontractors and bidders have to fill it in. We have less and less subcontractors identified by contracting authorities. Why? Because of administration. They do not want to tell us, to tell contracting authorities everything in a procedural phase. But afterwards, in the execution phase, they simply want to be as flexible as they can. So sometimes they identify subcontractors, sometimes not. Sometimes they change it. They do not want to sign contracts beforehand, before winning the contract. And we have a European Court of Justice's case that contracting authority cannot ask the potential bidders to sign a contract beforehand with the subcontractors. So it's pretty easy to hide subcontractors. And then if you want to control anything, then you will control just the identified subcontractors. So I do think that there are limits of this kind of control. And of course, the market players are able to learn very, very fast. So I'm a little bit skeptical. Of course, this is a very important opportunity, but not the only solution.
So thanks for the question. I mean, I take it, as you did, that this question relates substantially, at least, to the effectiveness of the post-award contract phase. In other words, the execution of the contract. And so your suggestion about new technology is, I think, directed at that phase. And I think that's an interesting way forward. The question, I think, is what's the incentive for that type of measure to be adopted, given the costs, given the administrative inconvenience, and so on. And I think, we were talking about this at lunchtime, I think one of the real problems at the execution phase, and I'm going to be really, really unpopular at this stage, is not just that the execution phase is very poorly monitored, but that the poor monitoring is actually built into the system, in the sense that the monitoring should take place from the point of view of the public authorities themselves. But I'm not sure what real incentive they have to do that, right? Because if they debar or find a fundamental violation, then they have to get another person to do the contract, for example. So the problem, I think, is that in particular these kinds of considerations, human rights, social considerations, are really to the benefit of third parties, not to the public authorities themselves. Right? So when we say, you shouldn't have slave labor, you shouldn't have trafficked labor, it's not the public authority that's benefiting. It's those who are trafficked, those who are in slave labor, right? So the problem is the disconnect between those for whom the contract is constructed to benefit and those who are able to enforce it. Right? And in most procurement contracts that I know of, the procurement contract is between the public authority and the contractor, and only those who are parties to the contract are able to sue on the contract. That's my understanding. Yeah, that's the ordinary contract rules. You may be from countries that have third-party enforcement of contract, but it's not mine. So the question is, why would you restrict enforcement of the contract to only the public authority to enforce the contract terms? Why wouldn't you open it up to the beneficiaries, those who are likely to benefit from the provisions themselves? I think the combination of these two ideas, your idea that you can actually do it through a technological element, but also my suggestion that you want to give other parties like NGOs, the incentive to actually do the monitoring, then I think you might be able to turn the corner in terms of making rather more effective monitoring. But it does depend then on essentially an external body to the public authority being engaged in the process of that monitoring in a way that might be more effective.
Since I see Jack, since I see Jack raising his hand, and he is obviously, as usual, free to say whatever he wants, but I wanted to challenge Ashraf, Amit, and Jack. Jack, when he opened the conference, he showed a graph which is typically used by Transparency International, which showed that everything to the east, in that case where you had a picture only of the east, is very red. And he says these are the countries where we operate. These are difficult countries for anti-corruption purposes. Obviously, the topic, I imagine I'm doing a parallel, can be exported to the issue of respect of human rights, both by governments in themselves and businesses. And so I think that this is a topic where maybe MDBs could say something about their view on how to tackle this issue, maybe because of their specific advantage point. And so maybe, I don't know what you wanted to say, maybe you wanted to talk about something completely different, But I would like just to give the floor to the three gentlemen in the front row, if you don't mind.
Well, my sort of line of thinking is not exactly totally clear at the moment, but I have a sort of a feeling here, and then it probably starts with saying that as a procurement manager, the more conferences I go to and the more I listen to all the topics that needs to be covered in procurement, I always feel totally underpaid. Yeah. And I think, point being here that I think you made very good points about sort of I like the way that you presented this obligation of the government also to make sure that their obligations are respected in any processes, really. It's a very fair point, and I think it's good. But the point is, in my opinion, that by whom? That is, for me, the key question, because I see the role of a procurement manager to be like a risk manager, a well-informed risk manager. Yeah? And I think that it's very clear that the procurement specialist cannot be a human rights lawyer, specialist in green procurement, know everything about how to fight fraud and corruption, social issues, etc., etc., etc. It's impossible, you know. So it goes back to the point that you are supposed to be the gel in combining those issues for which the government, in this case, we talk about the national level, you know, now we can also talk about the MDB level, meaning that the bank has certain requirements on how you do things in terms of, we have an environmental and social policy, we have the enforcement policy and procedures, and my point there is that, and also we have extremely complex projects which needs to be fulfilled. Yeah? So you need to have the engineering aspect, you have to have the legal aspect, the management aspect, and again back to this other issues that I was alluding to. You know? And the way in an MDB, in my opinion, how it works is that when I need to know how we should deal with fraud and corruption in the process, I go to my friend Rowan, who will give me extraordinarily good advice, give me the text that I'm supposed to put into the tender document, but also explains to me how we are going to address the issues when they arise and by whom, what's the process. And somehow I think that all those issues that we have been discussing during the day, and there are a couple of other issues that we could throw into this bucket, frankly speaking, I can say like this, to be a little bit controversial or provocative. You know, if you can't tell me what I'm supposed to have in a document and how to deal with it, how on earth am I going to do it? I mean, you are the real specialist, you know, in this. And the same goes for the environment, etc. And I think that's the point, you know, that we try to manage a process, but we need to have the context, the regulations, and the advice and the clear instructions. And unfortunately, I know this, I heard this at some point, that a tick box approach. I don't think it is a tick box approach. I see it as an informed way of putting together a process that takes into account all those issues which the government or the national legislation tells you needs to be respected. And then there are enforcement agencies, there are human, let's say those who works with human rights, etc., who needs to find out how to address those issues, not the procurement in itself. Yeah. I know that this is not a fully complete sort of answer. Yeah. Yeah.
Sure.
Thanks, Jack. Just building on what you've said, I think what's emerging from the last 3 days I've been here is that if you look at the magnitude of public procurement, and even in an advanced country like Netherlands, it's about 40% of GDP, clearly people have woken up and said, my God, we can hang a lot of things on this. So you want to hang human rights, you want to have green procurement, sustainable development, etc. Because the size of it is so big, I think people are seeing this opportunity. But I think where the analysis is wrong, and I want to support Jack in this, is that the procurement officers really come very late in the process, in MDBs, for example. And I think that's the same for the national planning process too. So you have national planners who will decide what project they want, what budget they want to set aside for it, what sort of objectives, social, economic objectives they want to have. And they will be the ones who formulate all this and then give it to the procurement guys and say, now, can you now procure me those? And so to put that burden on the procurement people, I think is totally unrealistic. Which is not to say that we shouldn't have all these wonderful things. I mean, why should we not use procurement for social objectives on which there is consensus? I don't think anyone can argue with that. But the process to get there, I think, has to be far more upfront with policymakers and etc. And I think that's where the emphasis, but like, when I was head of procurement in ADB 5-6 years ago, I had a number of people visit me to say, can you promote green procurement? And I said, well, I'd love to, but by the time I get to do anything, the die has been cast. Because if you're saying green procurement, then there are costs associated with that. And the guys who formulated the project have never taken those into account. So if you're now telling me to start putting in specifications for that, it's going to have a cost. And no one's got the budget for it. So I think that we need to be realistic about this.
Well, thank you so much, Gustavo, for asking us, surprising us with this question. Sure. I was starting to think about my presentation and how I'm going to do it when you came up with this. So if my presentation does not make any sense after that, so it's for you to blame. I think just following on what Jack and Hamid are saying, have said that maybe we are putting a lot on procurement. And just to respond to what you are saying, and just to emphasize also what they have said, it's not only on the policy side and what to include in contracts and so on, because as MDBs we do have many of these provisions in our contracts that we do against child labor and all this and all that. But we also have challenges when it comes to resources and how to enforce that on the other side. I mean, look more downstream. When we go to our projects, for example, and then we look at contractors, and we all hear, especially in our road projects, about wrongdoings by contractors, employees, to women in the communities, and child labor, and so on. And you go to visit those projects, and no matter what we do, we go as MDBs on supervision missions, we look at that, and we really don't have enough resources to prevent this or to do something really practical downstream. And when we rely on the government and our other authorities, they also don't have the capacity to be there and then. So it really goes beyond. It requires more, maybe to be more, not really to be more realistic, but really to think through not only upstream but downstream as well. Maybe this is the point that I would like to make. And I think you've raised this when, earlier in a question when you said that the contract, maybe implementation part, is the part that enjoys the lesser type of supervision and monitoring. Thank you.
So that's great. Thank you. Can I make about 3 or 4 points? The first is that it's taking up the idea of the procurement manager as a risk manager. And so this gets us to the interesting question of what exactly procurement expertise is for, and when it applies. So the first question in terms of what do procurement managers do is whether essentially their role begins after the definition of the subject matter and ends at the award stage. And in my experience, it tends to be regarded as that stage in between the definition of the subject matter and the award. And it seems to me that the point that was being made by Hamid is that somebody at least has to manage the preliminary stage and the subsequent stage. Now, there's a question about whether procurement needs to be expanded beyond what it's traditionally done to deal with the subject matter in collaboration with the policy department and to deal with the subsequent enforcement of it in collaboration with whoever it is that you want to collaborate. So there's a definitional question about what procurement expertise is supposed to deal with. But more fundamentally, I think there's a question about this notion about procurement managers being risk managers. And the reason why that's problematic in the human rights context is because it confirms my understanding, which is that essentially everything is brought into the mix, and the procurement manager's function is to manage that mix in such a way as to minimize risk, whether it be political risk, economic risk, legal risk, whatever. And I entirely understand that, I get that. The problem is that it then requires essentially, therefore, a balancing of various factors. And the problem in the human rights context is, well, some of these factors you just can't balance, right? So, if the question, I'm going to put it again rather bleakly, but if the choice is, do we save money, or do we allow a contractor to keep on torturing people, then that's not a trade-off that you can legitimately make under human rights understanding. So that's a problem, right? Because managing the risk does not meet the state's human rights obligations. And if the state thinks that you're the people who are doing that, who are meeting the human rights obligations in the procurement context, then I'm going to suggest that that's not going to fulfill their obligations. And there's a mismatch between their expectations of you and what you feel able to do. Okay? So then we come to this question about this first stage. So we've talked a bit about the last stage of enforcement, but let's turn to the first stage of the actual definition. That's partly why I raised the controversial question this morning about the actual definition of the subject matter of the contract. Yeah? And you're, I think, coming back to that question in terms of who should define the subject matter of the contract, and we're assuming that that's the function for that is in the policy department. But my question was, well, can you build human rights or gender or whatever into the subject matter of the contract itself? Right? So let's just think about that a bit, right? So what you're buying, therefore, hence the title of the book, what you're buying, the social considerations. You're saying the service that you are providing to me is in part selling me widgets, but also selling me widgets that are fair trade, or selling me widgets that are made according to properly paid labor, or whatever. Yeah? So that seems to me to be quite an interesting idea that meets your point of then getting the procurement practitioners in earlier into the stage, into the process. Is that workable?
This will lead for 2 days. I have Tunde that wants to answer, I have Ilya that wants to ask a question, and I have another fantastic session. And so I'm going to say big revenge on Jack that caught me this morning on the issues of, where did he cut me? Huh? Gender. Now I'm going to cut him and I'm going to give the floor to Tunde.
Thank you very much. So first of all, right now, this is an obligation for contracting authorities in most of the cases to deal with the topic. But the choice is how to do it. I think we do agree that this tick boxing solution, this let's create an awarding criteria and go home, that's okay, statistically we are ready, that's right now not enough. But what is happening, I think, and it has been started at 2010 approximately, that more and more best practices, worst practices like discrepancies arises, and we have more and more guidelines and benchmarks, Court of Justice's cases. And if you come back to the example of the Netherlands, let's look at this toolkit. It was developed by Piano, which is a think tank organization of the Netherlands, very well known. And they thought to do something to help practically for the contracting authorities. So they have created this toolkit for child labor-free procurement, just to make them understand how to identify, what does it mean, how to control, what would be the most useful disclaimer if they want to use. But of course, you cannot create a guideline for everybody because the culture and the level of understanding is completely different in the Netherlands, in Ethiopia, or in Serbia. But I do think that this way of thinking, and not contextual, but more not methodological, but in a way more useful way of helping contracting authorities would work. Because although we understand what human rights mean, in most of the cases, the contracting authorities, officers are not polyhisters. They don't know everything about their goods and services and supply chain and so on. So I do think this is the best way of understanding how to answer for this challenge. Thank you very much.
That was an applause to Tunde, not to the end of the session. That's right. Very good, because we have Ilya. Last question.
Does it work? Yeah, thank you. First, thank you for bringing up this subject to the table, so to say, because it's a really interesting and concerning subject. While you was describing all of this, I got myself to such idea. Actually, while we're talking about green procurement, gender procurement, it's not usually cost us to implement. Usually, if we think, for example, about green procurement, if in terms of life cycle costing, it could actually give us savings. And, well, in particular examples. About gender, it is even more obvious. Like if I'm a procurement officer concerning gender speciality that can allow me to do my job better, to achieve more value for the same money equals saving money. And I started to be really, really curious. Maybe there is the same ideas behind human rights procurement, so to say. So if we follow some ideas behind human rights, it can give us savings, which from my cynical officer point of view, actually is the best way to start to promote such good and bright ideas as human rights, gender procurement, green procurement, through procurement, and use procurement as a driver to promote these things. So it's not a small question. I just not specialist about human rights, so I don't know the whole ideas, but maybe there is something that could actually bring us savings. Because if it is, I'll be the first who do it, gladly. Thank you. Thank you again.
So that's a great question. Thank you. Can I say two things? One thing is that there was a bit of discussion this morning about differences between social procurement and green procurement. And I think one of the differences is that, and I think one of the reasons why it's easier to do green procurement, I'm not minimizing it, the difficulties, but the easier to do it, is because the kinds of costs that arise from environmental degradation are the kinds of costs that economists are quite prepared to monetize and to argue that essentially what you're doing is internalizing externalities. So the economics sort of works, yeah? And then the problem with the social and human rights, is that it's very difficult to conceptualize torture as an externality that has to be internalized. It just really doesn't work. That's why I asked the question, you know, how do you monetize human dignity? So I know you want to come back, but let me just finish in the second point. The second point essentially is the argument about the business case for human rights. And obviously, you know, politically and economically, it is of course sensible to try to use the business case for human rights wherever possible. The problem is when it doesn't work, when it actually means that it is more expensive to produce these goods, when somebody has to pay. And in that case, when the business case doesn't work, sort of the whole point of making human rights a legal obligation is you still have to do it. And so the problem then is making that commitment by a state. Remember, states don't have to sign up to these commitments. They do it voluntarily. The question is how to make those commitments realistic, even when it isn't supported by a business case.
There's a nice book that I would recommend, which I always thought, no, you're not going to speak. There's a nice book that I never saw in terms of procurement, which I recommend for those of you who haven't read it. It's by a philosopher at Harvard. It's called What Money Can't Buy.
Right.
By Sandel, I think that's
Sandel,
his name. Yes.
Michael Sandel, yeah.
And he puts into perspective these kind of issues, and maybe we should read that book having also procurement in mind. I could feel the tension in the room, and it's 3:40, and I think that the tension was not about when is this session going to end, but really of the interest of all the people. So I really thank our two wonderful speakers for this fantastic session that they gave us.